Thank you, Mr. Chairman, and welcome, Attorney General. Mr. Dellinger, one of the things that your testimony has kind of talked around it about what we call this thing, and it's always intrigued me that the label is so important. People pretty well accept the idea that if you go to a gas station with a credit card, it should be prohibited to charge you extra for using the credit card. However, people think it ought to be permissible to have a cash discount. And so if there are two prices, one, a credit card price, and then a lower cash price, if you call it a penalty for using a credit card, that's bad. But if you call it the same differential, if you call it a cash discount, then that should be permissible. And it seems to me that we're in the same situation on what we call this thing. There's no mandate. If you don't have the insurance, you pay the tax. If everybody's paying the tax, if we'd call this thing a tax credit for having insurance, would that have made a difference? Because there's no mandate in calling it a tax credit for having insurance. That would mean that Mr. Cuccinelli couldn't label it a mandate and couldn't label it a penalty. If you called it a tax credit, would that have made a constitutional difference?
I don't think it should, because even when you consider it as a Commerce Clause matter, the fact that it's clearly within commerce and would be unremarkable if it were done unmistakably as a tax credit for having coverage rather than an additional tax penalty for not having coverage, it seems that that is very deeply non-intrusive. You know, your notion about
but that's what we're here about. We're here about the penalty, the mandate. If we had called it a tax credit, would it have made a difference?
It shouldn't, and it just would have changed the rhetoric.
Mr. Cuccinelli, would it have made a difference if we'd called it a tax credit?
As I mentioned earlier, if the structure was as it is now in the bill, and you change the word penalty to, negative tax credit or something, the substance is still the same, and it is the substance that the Supreme Court has looked to historically. It does not operate as a tax, therefore it is not a tax, therefore it does not fall under the taxing and spending power for the general welfare.
I mean,
so
you get
it
a
will
tax
have
credit.
to
You get a
survive
tax
on some other basis.
You can get a tax credit for solar panels. Well, you don't have to buy a solar panel, but if you do, you get a tax credit for it.
Well, the critical distinction in your point, and it goes to the earlier sort of shift from Mr. Nadler over to Wickard v. Filburn, is yes, but if you compelled the purchase of solar panels, we'd be in a totally different category. And much like the Wickard case,
we don't compel the insurance. If you don't have insurance, you pay the extra tax. So you get a tax credit. You don't have the tax credit for insurance.
You do, in fact, compel it, and you provide a punishment for those who don't obey the compulsion.
That's exactly
the Wickard case, the wheat case, I'm sure you all are familiar with, would have been like this legislation if Wickard was compelled to grow wheat. He was not, but he chose to do so and therefore was governed because his activities, voluntarily engaged in, were subject to regulation under the Commerce Clause.
And you have labeled it a mandate when there's no mandate. You don't have to buy insurance.
Well, if you don't, you're not obeying the law.
You pay the extra penalty. Is that, Mr. Dellinger, is that? If you don't have insurance, you have to pay the tax. You don't get the tax credit. And if we'd label this a tax credit for having insurance, we wouldn't be here.
You still have the structural problem of the legislation as it is. The words on it, if I could ask you,
if we'd had a different differential, those with insurance will pay. Will pay. Those without insurance will pay a tax. Those with insurance get a tax credit, and will not have to pay that extra tax. Would that make a difference?
Well, you give tax credits for various forms of insurance that are purchased, and,
That's right.
and at least that tax credit, standing on its own, has never been challenged, so far as I know.
So, Mr. Dellinger, if we labeled it different, would we have a different conclusion?
I think your question very effectively points out the fact that this simply isn't very intrusive. If it's just the flip side of providing a tax credit, a modest tax credit for maintaining insurance, by having instead a modest tax penalty for not maintaining insurance, how is this the end of liberty as we know it?
Well, is it true that there's not a mandate to have insurance?
Well, there is a freestanding requirement in the bill, precatory requirement that everyone should have coverage unless they already have Medicare or Medicaid or they're below the poverty level.
And
But
if
the
we're
pen-
lab-
the
if we're lab-
penalty provision, you can only applies to people who engage in certain activities, which I'll describe. But you can search the bill for the word individual mandate. It nowhere appears. You can search the bill.
So do you have the difference, if we'd labeled it tax credit, we would have avoided a lot of this controversy.
Absolutely, and it can't be that a mere labeling like that is something on which turns some great issue of liberty. If you ask an ordinary person to say, look, if you're sitting out in the woods, you don't have to buy insurance because there's no penalty that attaches to it. If you go to work in the economy, they're going to deduct money for Social Security for your old age. They're going to deduct money for your Medicare, for health care after you're 65, and they're going to add a 2.5% tax penalty to pay for coverage before you're 65 unless you're maintaining minimum coverage. No one's going to say, well, gosh, one of those is the end of liberty as we know it, and the other two are all right. In fact, this argument sounds exactly like the arguments over the challenge to Social Security. And those attacking Social Security said, if Congress can mandate a retirement age of 65, financial support for those over 65, they could set the retirement age at 30 or 25. The Supreme Court said Congress is never going to do that. That doesn't mean it's unconstitutional. People said when the minimum wage law was passed, if you can have a minimum wage of $10 an hour, why couldn't Congress set a minimum wage at $5,000 an hour? And once again, the court said Congress is never going to do that. That, I think, really hardly counts as an argument. But no one would think of this as unremarkable. No one is going to go with bayonets and force march you to some insurance agency. It's just a financial incentive to maintain minimum coverage, as your questions point out.
Yeah, the gentleman's time has expired.